Hi, it's Musharraf Hussain with the subject of interpreting taxing statutes. Our today's topic is equity and morality. Equity. First of all, we should know that equity is not equality. It should not be confused with equality. Equity is a kind of justice, whereas equality is the state of being equal. So both have completely different meaning. Equity owes its origin to mercy. In England, when the legal rules was not sufficient enough to deliver justice, the aggrieved approached the king, the fountain of justice, for mercy. King, being above the law, delivered justice by going beyond the law using his good conscience. With the rise in number of mercy petitions, the King of England established a court of Chancery to dispose of these petitions. The Court of Chancery was freed from the constraints of legal rules. It disposed of the petitions using justice, equity, and good conscience. Court of Chancery was fused with the Common Law Court in 1875 through the Judicature Act of 1875. But before its fusion with Common Law Court in 1875, it delivered a number of decisions which became rule of equity. Now, means after 1875, the Common Law Court in England is imbued with equity. It can decide the case in accordance with the legal principles in consonance with the principles of justice, equity, and good conscience, so that the justice gets delivered without any frustration. There are certain general principles upon which the Court of Chancery exercised its jurisdiction, known as Maxims. Snell, in his book on principles of equity, has summarized these as follows. First, equity will not suffer a wrong to be without a remedy. Equity follows the law, that is, it is supplementary to law. He who seeks equity must do equity. He who comes into equity must come with clean hands. Delay defeats equities. That is, equity aids the vigilant and not the indolent. Equality is equity. This equality and equity shall be distinguished from what we said earlier, that equity is not equality. Here the emphasis is that equality may be one of the attribute of equity. This equality specifically is about division of property. If something is divided, a common thing is divided, then it should be divided in equal proportion. Equity looks to the intent rather than to the form, also known as substance over form. Equity looks on that as done which ought to be done. Equity imputes an intention to fulfill an obligation. Where there is equal equity, the law shall prevail. Where the equities are equal, the first in time shall prevail. Equity acts in personam. In personam means against a person. Equity does not act against a thing. So equity is not now a mere mercy of the court, rather a process to fill the gap of law to save justice from frustration. Equity may now be summed up as the moral virtue of fairness applied for the sake of justice, where the law fails to deliver justice because of subtle defect or lacuna in law. The rules of equity enunciated by the Court of Chancery have been recognized by the legal system with the passage of time in the form of equitable rights and remedies. Instance of equitable right may be given of the beneficial interest which a beneficiary of a trust has against the trustee who has the legal interest over the property, as mentioned in the chapter 6 of the Indian Trust Act 1882. Instance of equal remedy may be given of quantum merit, whereby a party may recover the reasonable value of services rendered to another when such service was non-gratuitous and the other party enjoyed the benefit, as mentioned in the Indian Contract Act 1872, Section 70. Several equitable rights and remedies evolved by the Equity Chancery Court have been recognized in following Indian legislation, like Specific Relief Act 1877, Indian Trust Act 1882, Guardians and Wards Act 1890, Indian Contract Act 1872, Transfer of Property Act 1882, Indian Divorce Act 1869. Indian courts, especially after independence I'm talking about, are a court of law as well as of equity. And whenever they find a lacuna or defect in law frustrating justice, they apply the principles of justice, equity, and good conscience. One may refer for benefit the case of Indira Bai versus Nandkishore, 1990, volume 4, SCC, page number 668. Now come to morality. Morality is a normative pattern which aims at the augmentation of good and the reduction of evil in individual and social life. Though in the age of hedonism, where self-interest is all pervading, the discussion on morality appears nonsensical. But one should not forget that morality is the foundation of law. In the primitive society, where there was no concrete rule of recognition, ethical system caused social ordering and coexistence. An ethical system is composed of morality to create tolerable conditions of social existence. Kant's theory of morality. The great philosopher Kant said that morality is autonomous, coming from within man's soul, while the law is heteronomous, being imposed upon man from outside. He said that the moral imperative demands that men act from praiseworthy intentions, above all from a sense of ethical duty, and that they strive after good for its own sake. No outward physical compulsion and threats, but the inner conviction of the inherent rightness brings about the realization of moral norms. He said that law regulates the external relations of men, while morality governs their inner life and motivations. Law requires external compliance with existing rules and regulations, regardless of the underlying motive, while morality appeals to the conscience of man. But this theory has been criticized, especially about the internal and external sources. Critics of Kantian theory of morality says that the primary source of moral commands cannot be found located in the autonomous region of individuals. Ethical systems owe their origin to the strong desire of organized groups to create tolerable conditions of social existence. Tenets of social morality are devised in order to curb intra-group aggressiveness, reduce predatory and unconscionable practices, cultivate concern for one's fellow men, and thereby increase the possibilities of a harmonious coexistence. So, social morality may, with good reason, be looked upon as the recognition of an objective hierarchy of values which are to guide the conduct of human beings towards one another in a governed society. Within this hierarchy of moral values, we may distinguish two categories of postulates and principles. The first category consists of requirements of social ordering which are deemed indispensable or necessary or highly desirable for an effective discharge of the task an organized society has to cope with, like avoidance of violence and injury, the keeping of faith in the performance of agreements, regulation of family relations, and perhaps some degree of loyalty towards the group may be counted among these basic requirements. These basic moral rights are considered imperative for social intercourse and are transformed into law. For example, the prohibition of murder, rape, robbery, and physical assaults, the interdiction of fraud and bad faith in the conclusion and performance of consensual agreements, etc. The second category of moral norms includes principles which add greatly to the quality of life and the establishment of closely knit bonds among men, but which demand more of human beings than is regarded necessary for the preservation of the essential conditions of social existence. The values, for example, the values of generosity, benevolence, charity, unselfishness, and loving kindness belong to this second category. These precepts of pure morality require lesser obligations, that is, the degree of autonomy accorded to men in such matter is greater than the sphere of free volition allowed by regulatory norms of law. So one may feel a moral obligation to release the debt of a person in financial straits, but the debtor has no right to demand such generosity. So purely moral postulates are not covered by whatever enforcement system is available for the vindication of rights. Thus we may say that moral precepts may be distinguished from legal rules, but the boundaries between these two categories of social norms cannot always be drawn with sharpness and precision. What Mr. Kant has done. Taxing statutes and equity. Taxing statutes are to be construed strictly without giving place to morality or equity. In a taxing act, one has to look merely at what is clearly said. There is no room for any intendment. There is no equity about a tax. There is no presumption as to tax. Nothing is to be read in. Nothing is to be implied. One can only look fairly at the language used. This was held very long back in an English case of K. Brandy Syndicate versus IRC in 1921, Volume 1, King's Bench 64, page number 64. This English precedent was followed in CIT Madras versus MRP firm, reported in AIR 1965 Supreme Court, page number 1216, in following terms. Equity is out of place in tax law. A particular income is either eligible to tax under the taxing statute or it is not. But this strict construction, however, has been limited to the charging provisions. Machinery provisions, which are to effectuate the charging provisions, owe an ordinary construction, as was held in Murari Lal Mahabir Prasad versus B.R. Wad, 1975, Volume 2, SCC, page number 736. One instance where equity has been recognized in the taxing statutes is of doctrine of substantial compliance. The doctrine of substantial compliance is a judicial invention, equitable in nature, designed to avoid hardship in cases where a party does all that can reasonably expected of it, but failed or defaulted or faulted in some minor or inconsequent aspects which cannot be described as the essence or the substance of the requirement, as was held in CCE New Delhi versus Harichand Shri Gopal, 2011, Volume 1, SCC, page 236. From the viewpoint of an economist, equity implies fairness in the distribution of burden of taxes on the subjects. Equity is further classified by economists into horizontal and vertical. Horizontal equity is maintained by ensuring the distribution of tax in such a way that those who are essentially equal should be taxed equally, whereas vertical equity is of treating or taxing people differently with different levels of income. But such abstract principle of equity cannot determine the complex tax structure of the state as warned by Samuelson in his book on economics. Thank you.